Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, Certificate in Social Work and Criminal Justice System, CSWCJS. MSW32 Social Work and Criminal Justice. Block-2 Concept of Criminal Justice Administration in India. Unit-1 Concept of Criminal Justice Administration, 1.0 Objectives. By the end of this unit, you will be able to delineate the purpose of criminal justice system, understand the evolution of the criminal justice system, and recognize the components of the criminal justice system. 1.1 Introduction. Criminal justice system, CJS, is an apparatus that is employed by the government to enforce standards of conduct required by the rule of law from the people. Subject to authority. The civilized society from time immemorial have devised various methods of punishment to control and contain the increasing crime wave. The major components of the criminal justice system are police, prosecutor, judiciary and prisons, known now as correctional institutions under the modern correctional philosophy. The subsystems like prosecution, defense, probation, and parole and allied officers also have very important role in the criminal justice system. All the components of the system and other segments are interrelated with each other. What is done in one component or segment has a direct bearing upon the other components or segments. Police is the entry point in the system, as they constitute the cutting edge of the formal CJS. The raw facts about every incident of crime enter the CJS through either a report of police to a magistrate. Such reporting or complaint about crime sets into motion investigation by the executive, the police, that is empowered to collect the best evidence, interrogate witness, arrest, search and seize etc. Exercise of power of arrest necessitates conferring power of bail in appropriate cases. In every case, a successful investigation leads either to a positive charge sheet or a negative report for the prosecution. 1.2 Purpose of the criminal justice system. Every society is committed to orderliness, peace and justice. There exist elements in each and every society who create law and order problems. The basic purpose of the criminal justice system is to provide every possible protection to the person and property of the people and to bring the lawbreakers to the book. In other words, the underlying principle of the criminal justice system is to provide justice to both the criminal as well as the victim. It may be pertinent to mention here that it is only a small portion of the crimes committed which are reported to the police, and again out of the crimes reported to the police a small number goes to the court for trial. Lastly, a very small number of the cases which are put to trial in the court of law reach to the logical conclusion. There are inordinate delays in the disposal of the cases, consequently pressure is mounted on the criminal justice system and people lose faith in the system. The quality of the civil society to great extent depends upon the performance of the criminal justice system in discharging its basic function, which among others includes the maintenance of law and other. But the CJS has to keep an eye both on its efficiency as well as credibility. This, a CJS that claims to have high arrest rate and higher conviction rate may still not be ideal if it has a low credibility rate in the eyes of the general public. 1.3 Evolution of the criminal justice system. The mankind right from its inception has devised various means and measures to maintain law and order in the society and control the criminal tendencies among its midst. The mechanism to control the criminal behavior varies from society to society and in the same society from time to time. However, the mechanism by and large involves the process of arrest, trial and punishment. The mechanism of arrest, trial and punishment undergoes major changes with the progress of civilization, as well as socio-economic and political conditions prevailing during different phases of history that go into the evolution and growth of the system. Pillai, 2000, has expressed that evolution of penal law has three main stages. The first stage being that of strict liability, the second stage revolves around moral wickedness or guilty mind. The concept of moral wickedness was supplemented by the test of foresight of the consequences. Criminal justice system has a long historical perspective. Crown in England, during the 12th century, gradually assumed control over administration of justice, and the compensation was to be paid to the crown rather than to the victim. However, no formal techniques were devised. Criminal justice system prior to the 18th century was characterized by the informal techniques. In the ancient era, some formalized legal codes and the state-administered procedures can be traced out which outline the functioning of the criminal justice system. The Code of Hammurabi, developed by the King Hammurabi of Babylon in 18th century BC, was the earliest known system of laws. This code was designated to regulate a wide variety of human affairs. Criminal justice system in the ancient India, as maintained by Dwivedi, 2004, was governed by drama, as law of drama propounded in Vedas was considered supreme in the ancient India. The right to punish the offender rested with king. The ancient Hindu law did not expressly distinguish between crime and civil wrong, but the king, with the progress and development of the society, started making laws and regulation in the light of prevailing local customs and usages. The changes in the system were very slow but gradual. After the conquest of the country by the Muslims, Muslim law was introduced in India, and the Indian courts applied Muslim criminal law in the administration of justice. Misra, 2004, has pointed out that the main source of the Muslim criminal law was the Holy Quran and Hadith. The Qazis were responsible for elucidating and expounding of the laws. The Muslim criminal law divided crimes as crimes against God like adultery and drunkenness and crimes against man like murder and robbery. The crimes against God were regarded as public wrong and were punishable by the society or community. The offenses against man were regarded as private and were punishable, but the victim's next kin had very vital role so far as the nature and quantum of punishment was concerned. The matter could be closed with a payment of compensation, what in most of the cases was known as blood money. The punishment was mainly of four types, namely, qisas, retaliation, diyut, blood money, had, defined punishment, and tazar and siyasa, discretionary and exemplary punishment as per the Muslim law. But it continued till the administration of justice was taken over by the East India Company. The first attempt to modify the nature of punishments was done by Warren Hastings, and it was followed by a number of reforms in the substantive criminal law introduced by Lord Cornwallis. A number of laws were introduced on piecemeal basis, but each presidency had its rules and regulations, and they differed on many counts from each other. The disparities in the rules and regulations surfaced when all the presidencies were brought under common rule, and it was realized that piecemeal reforms may not yield the desired results, and in order to overcome the conflicting rules, the Charter of 1833 was enacted, which gave birth to the All India Legislature, office of the law member in the Council of the Governor General, and provision was also made for the establishment of the Law Commission. The first Law Commission was appointed in 1834 with Lord Macaulay as its chairman. The commission submitted its draft report to the Legislature Council. The Legislature Council endorsed it to the Governor General for his consent. Governor General approved the revised draft penal code, and it came in force on 1st January 1862. The penal code defines crimes and criminal behavior. The criminal procedure lays down the procedure for trial of the offenses. The law of evidence deals with the evidence, and the Constitution, besides various vital issues, deals with rights and duties of both the state as well as the subjects. There are various other laws which define offenses, confer rights and duties, lay down the procedures to deal with the specific offenses. Further, courts have also played their role while interpreting the legal provisions. In fact, judicial activism has to a great extent helped in the growth of the criminal justice system. 1.4 Components of the criminal justice system. The task of prevention and control of crime mainly belongs to the criminal justice system, and in general involves the process of arrest, trial, conviction, sentencing, punishment, treatment, and finally rehabilitation. The basic parameters are laid down by the legislature in the form of law. The main components of the criminal justice system are police, judiciary, and correctional institutions. The legislature is also an important component of the criminal justice system, as all the laws emanate from the flow of the legislature. The courts interpret the laws, and police is the executing agency. The components of the criminal justice system are given in the following diagram. Components of the criminal justice system. Look at the screen. Each component has no doubt a distinct role, but all the components are interconnected with each other. The police is the first agency to get information about the criminal incident and pursuant to it undertakes investigation of the crime. Prosecution is the second in line, as it scrutinizes the charge sheet of the police. The judiciary takes cognizance of the crime and adjudicates the allegation of crime. The correctional agencies like prisons and probation come at the end. The functioning of the key functionaries in each component has a direct bearing upon the functioning of the other components. They are interdependent upon each other and influence each other's functioning. 1.6 Summary. The concept of criminal justice system is related with the concept of crime and norms of the society to control the criminal activities. It is as old as the mankind in itself. The methods to control the crime have been devised by the society from time to time as per the perception of the crime. The agenda for the criminal justice system is reflected in the socio-economic and moral values of the society, which in the due course of time, takes the shape of legal norms to become the binding force for the society. The methods to control the crime have always depended on the perception of the crime in the society, social sanctions, vigor, and force of the state. The Indian criminal justice system has traveled through Hindu period, Muslim period and finally the present shape. Justice during the Hindu period and Muslim period was swift and within the reach of common people. In the post-independence period, law has been amended from time to time to make the criminal justice apparatus swift and more effective. The criminal justice system including the police apparatus is the reflection of the existing social setup. The legal norms get executed through the apparatus of the criminal justice system, which in any civilized society has to be fair, firm, impartial and effective. Thank you for watching. We will see you in the next video with the next chapter.